Dear students, this is Harinaganand Idumudi, English Shorthand Instructor. To get updates with regard to our channel, please subscribe. Our channel name is Shorthand Hub for General and Legal Dictations. If you want to join in my WhatsApp group, please send a message to 970 44 55 002. 5 seconds. Start. Eventually, on appreciation of facts, it has been concluded that the petitioner therein has been facing serious allegations of misconduct, and as such, it is entirely wrong on the part of the tribunal to interfere with the orders of suspension. Accordingly, the Honorable Supreme Court has restored the order of suspension, setting aside the order of the Administrative Tribunal. On a close scrutiny of the judgment relied on by the learned counsel for the petitioner, I do not see any proposition of law forthcoming therein in support of the contention of the learned counsel for the petitioner that any employee shall not be placed under suspension merely on a premise that he occupies law position of the rank, or that his continuation would be totally harmless to the organization. In any event, the role the petitioner plays pending inquiry, if he is kept in service, is at best within the exclusive knowledge of the management of the corporation, which alone is competent to visualize the consequences either on account of the petitioner having been placed under suspension or otherwise. As such, I am afraid the decision referred to may not have potential or upsetting the order of suspension passed against the petitioner. A constitutional bench of the Supreme Court has dealt with Rule 3, Sub Rule 1 of All India Services, wherein it has been specifically stipulated that an employee can be placed under suspension only on actual initiation or commencement of disciplinary proceedings, but not in contemplation thereof. Whereas in the present instant, Rule 8 of CCA rules is absolutely categoric to the effect that an employee can be placed under suspension even in contemplation of disciplinary proceedings. As such, the ratio in PR Nayak doesn't have any application to the present set of facts. Eventually, I am referred to a decision of the Central Administrative Tribunal, Bangalore, in M. Sankarnarayana vs. State of Karnataka and others, which is in the words of the Land Council for the petitioner is locus classicus. This case may not be a precedent since reliance has been placed on it. It is fair on the part of this court to examine the ratio laid therein by the learned Central Administrative Tribunal, Bangalore. In an elaborate judgment, the learned tribunal, having referred to various judicial pronouncements of the Honorable Supreme Court as well as High Courts, has eventually held that the government servants ought to be placed under suspension in terms of the guidelines governing those employees. In fact, the learned tribunal has extracted the guidelines concerning the employee in question and has eventually held that none of those guidelines empower the authorities to place the employee under suspension in contemplation of any disciplinary proceedings. Having appreciated all the above judicial dicta having unquestionable efficacy, at the same time an appreciation of the present set of facts, I may have to observe that under all circumstances, especially in service jurisprudence, there can't be any invariable principles having precedential values, save based on the statutory scheme holding the field. In other words, every aspect of service jurisprudence depends on the rules governing the particular employees, since they are mostly executive instructions in nature given in terms of Article 309 or in terms of Article 162 of the Constitution of India.